really sick. And then so for a few days, especially with driving, you know, an hour, when I got out of the car, I couldn't stand up. Yeah. So anyway, so I told him, I'm not good for very long tonight, so.
Broke their hearts.
No doubt. That's some good stuff.
You getting nervous for the results?
No.
You're not?
Oh. Have you ever had to argue whether an expert could offer an expert opinion?
It said they're mailing out the results on Saturday, which means I think
You know what? No, once. Right. And it wasn't even. It really wasn't close. I was
I don't know. They said they're mailing it
out in
I figured we're gonna get it.
in front of Judge Cribs
Oh yeah.
with Michael Kennedy. And Michael Kennedy filed a Kelly Fry motion on cell tower technology. Right? We had cell locations.
This is totally not a scientific.
Yeah, and he argued,
Really focusing on
and we put on the hearing, we did it.
because you have like
It's not a scientific method. So generally accepted in the scientific community is not against it.
If we don't,
Yeah.
they have 5 weeks.
Like we argued it,
And you could like do a little bit.
Cribs, I like Cribs, I like the hearing from him, but in his Cribs ways, and you know what, yeah, I'm
That's my whole.
I'm gonna deny your permission, but field's open to you.
Ah, whatever that means.
Whatever that's
It's always like it.
you know.
BJ would always do that.
Yeah.
No, the objections overruled the field open.
What the hell does that mean?
Objections to state that the field is open. What do you even mean? I mean, I had one that involved the reporter's privilege in a trial with my BJ. And you can try to apply the reporter's privilege. The LA Times sent a lawyer with their witness.
Oh, man.
Yeah, so yeah, that's just made BJ's week, I'm sure. And every question I asked, and every question the other lawyer asked, the lawyer made the same. The
That's a lot.
Times lawyer made the same.
I mean, so all you need is working.
Yeah.
You know, that, you know, what was interesting is, I know people in the DA's office who might just get fits.
What?
Like, just get them, they just don't like them, have a hard time with
Well,
this.
that I can understand.
And I'm like, but you, for me, it's
Don't let them get into your skin.
and it's him outside the courtroom is different than him in the courtroom.
Like, I've had to chew him out a couple times where I felt that, I've had to chew him out a couple times where I felt he was being disrespectful. Like, there was one time in a preliminary hearing where he accused, you know, basically everyone of being biased against his client. I'm like, whoa. You can argue that the police were and the way they did the investigation, but what you're saying makes it sound like I am. You have no basis for that. That is actually contemptuous to accuse me of being unfair when I'm not being unfair. And it had to do with his client's father got in the witness stand and said, that weapon, that assault weapon in the back of the car, that was mine. And he was trying to tell me that I had to believe the father. Well, the police have a reason to lie. Dad has a reason why. I think there's a reasonable inference to be drawn that Dad's just making this shit up to try to help his son out. Because he knows that nobody's going to actually believe that the weapon is his.
Right. He chased, of course, he chased stuff. It's a cat.
Yeah. Well,
I just remember, you know, he had this persona, and I don't know if he still tries to do it, Captain Motion.
Right.
He's gonna, if you gotta pay for them, expect emotion.
Yeah.
It's coming.
Yeah.
That's
What
what
he's gonna delay before filing said for the notice. I had him where he got hired after the verdict and was bringing a motion for a new trial, and it took months and months. And he was sick. And the daughter or the sister of the victim was pissed. And was really mad at me the last couple times that I gave him more time. But I was like, look, I'm giving him all the time he wants so that when this goes up on appeal, the court of appeal doesn't say, well, you should have given him a little more time to bring his new trial motion. And so finally, to hear the new trial motion, he's arguing actual innocence. And I'm like, you know, Mr. Kennedy, I have the benefit of actually being in the trial with you. I saw those witnesses testify. I saw that witness that you claim was clearly lying. I believed him. And so, you know, thanks.
Right.
No.
Right.
And you guys give him a whopping. That's what he deserves. It was a kidnap murder, and they shot the guy out in the middle of the freaking nowhere. He was a dead guy. And his bones, and they burned the body, and the bones were found by some hikers a few months later. Wow. But there was a piece of skull with a partial bullet hole. So once they identified the remains, they're like, yeah, well, this dude definitely got shot.
He got shot. Oh, that was just target practice or something.
Yeah,
bad.
Right. No, we had the DA had to bring back a coroner who had retired or left or something. It was, but that was some interesting expert testimony.
I'm ready to give up this week.
Fortunately, they stipulated that the remains were the dead guys, so we didn't have to get into a whole bunch of DNA stuff. But the testimony from the coroner about cause of death and all that was really good.
Yeah, I bet you that would be very good.
Yeah. And you know, the jurors just found it fascinating, right?
Oh,
That's the indication you want to get, right?
Absolutely. All right, guys. Everybody ready? Hello, hello. Is this on? Yeah. All right, you all can't wait for tonight, right?
Right.
Because this is the fun part. Aside from your closing argument, you know, in a trial, when you get to really stand up and deliver, you know, what we all went to law school for. So we could stand up and give that summation. This is next in line with as good as it gets. When you have a really good cross-examination and you really impeach that witness, it feels really good. And it takes time, and it takes effort, and it takes some strategy on your part, and it takes knowing the rules on how to do it. But
and it's also really easy to screw up.
Yes. And very few attorneys do it well. They just don't. You know, they stand up there and they ask all the same questions that the other side just asked, and all they're getting is that witness to repeat the exact same information that's hurting their case again.
Only now it's got some credibility because you brought it up.
So this can be really, really fun. It's a great part of the trial, and if you put time and effort into a good cross-examination, it's wonderful. Like I said, even when you put time and effort in, it doesn't necessarily come out well. A lot of factors go into play with whether it comes out that way. But every once in a while, you know, it just shines. And I had this one case, which, you know, I had one of those moments where I was cross-examining the defendant's sister. And she just got up in the middle, gave up. I quit. F this shit. And got up and walked out. And we all stood there, and the judge looked over to his deputy. Deputy walked out, brought her right back while we were all waiting. And at that point, I was done. Right? Whatever else she had to say.
You don't want to slap her around anymore?
You know, whatever else she had to say wasn't going anywhere. Okay? So when you can And it happens. I mean, a good cross-examination, I'm sure you've seen them.
Absolutely.
Yeah,
And I'll tell you, I worked on an antitrust case years ago, and the chairman of American Airlines was testifying about why his company lowered prices. And that was the supposed antitrust violation. And he did a masterful job on direct, right, for 2-3 hours of explaining all about the economics, why they did this, want a fair level playing field, fair competition, all this. And then with about half an hour, 45 minutes left in the day, David Boyce started cross-examining him. And he went from this confident, not really smiling, because he never really smiled, guy who's a chief executive and, you know, he's in control, to his arms were crossed, his legs were crossed, he had this snarl on his face. And that was all because Boyce was doing a good job of scoring some points on cross-examination with him. And the transformation was amazing.
So, you guys felt that same way when you were reading these rules, right? Well, cross-examination is one of those things where a bunch of things come together, okay? Clearly, the rules don't cover everything you can do on cross-examination and impeachment, but they cover some of them. And the rest of them, for the most part, are going to be found in just your common sense and case authorities, okay? So when you're looking at cross-examining somebody, clearly their character for a truthfulness or untruthfulness comes into play. The rules will cover that, right? If they've made false statements or you've got specific acts of dishonesty, right? The rules will cover that. If they've got prior convictions, right? We're going to get to that. The rules are there. But do they have biases that are relevant to the case, right? Do they have an interest in the outcome of the case, right? Have they made prior statements that are inconsistent, right? Drugs, alcohol, mental impairments, poor eyesight, poor hearing, right? Unreliable memory. These are all areas that you get to explore on cross-examination, and the rules don't cover all that, okay? Your main goal in cross-examining somebody is to leave the jury with the belief that they can't rely on this testimony. For whatever reason, amongst those ones that we just talked about, for whatever reason, we can't trust this person. Doesn't mean they're lying or they're untruthful, but we can't trust them because they say they saw something and they don't have good vision, or it was dark, or their memory's not clear on that. Doesn't mean they're lying, it just means they're not a witness that you can rely on. Okay, so those are all areas. And if you think you're ever going to ask somebody, well, aren't you lying? Well, yes, I am. Right? That doesn't happen.
Except on Perry Mason.
Yeah, except on Perry Mason. But you absolutely can leave the jury with the impression, is he lying? And they're going to say, yes, he is.
But don't go for that unless you're real sure that you're actually going to be able to convince the jury the person's lying. Because jurors don't like to think that someone would come in, take an oath to tell the truth, and sit there and lie to them. And if you accuse somebody of lying and the jury doesn't think you have the goods, guess who they're going to not like? You.
So you all should have gotten this nice little cheat sheet. Most of this is not found in the rules. Some of it is, okay, but most of this isn't, okay? When you're challenging the reliability of testimony, right, it's gonna depend on the quality of the witness's perception, their interpretation, their memory, and their truthfulness. Right? Those are the 4 areas that you want to be able to attack. Okay? If they don't have any perception, you exclude it under 602. Why?
Because they don't have anything to tell us. If they literally didn't perceive anything, if they don't have personal knowledge, they can't tell us anything, right?
Their interpretation, right, if they don't have any, right, you're gonna exclude it under 701 to 702. Right, if they've got no memory, you exclude it. If they got no truthfulness, well, you let them testify, right? There's no rule on that. Okay?
Yeah,
If
the judge doesn't get to say, hey, that witness is lying, she can't testify, right? It'd be nice, it'd be a lot of fun.
So everything else, right, if they've got some of these things, but your position is that they're just flawed, right? If you think their perceptions are flawed, could be poor opportunity to observe, poor eyesight, intoxication, mental impairment, right? Their interpretation skills, right? Under our opinion rules, right? Maybe they've got a lack of experience. They've got lack of proper training. Maybe they're biased, right? We talked about when we went through the character rules, you know, as somebody comes in and says, this guy's the kindest person in the whole wide world. And it doesn't matter how many specific acts you hit this person with to demonstrate that they're not all that kind, they will never change their opinion because they're biased, right? They're coming in to testify that their buddy is a kind person and you're not going to get them to change their mind. And it doesn't matter how hard you try, right? Do they have a self-interest in the case? Same thing with memory, right? Have they given prior inconsistent statements? Is there an inability to remember similar things, right? It's interesting when you go through somebody's testimony and everything that helps them, they remember.
Yeah.
Any other details around that exact same event, they don't have a clue. Well, I don't remember. I don't remember. I don't remember. But you remember A, B, C, and D, and we're in the same room, same people, same time, same event, but you don't remember anything else? Nope. I know that guy was wearing a blue shirt. Okay. And what was the guy next to him wearing? I don't remember. Right? so, you know, have they been exposed to new information? Have their memory, is it based on what they've learned after the fact, not what they knew at the time of the incident? And again, do they have a self-interest? And if you're looking to impeach somebody on their truthfulness, have they made prior inconsistent statements or have they acted in an inconsistent way? Do they have a dishonest character? Right, that's going to be covered by the rules. Are they biased? Do they have a self-interest? Are they a felon? Right, those are all areas that you can explore when going after somebody's in the area of truthfulness. Some witnesses, you might want to hit them on all four of these. Some you're only going to focus on one, right? If it's your task in your mind to cross-examine every witness that ever comes up against you and prove they're lying, you're going at it the wrong way, right? Because not everybody is going to be lying against you, right? So you've got to find these other ways and these other areas to attack them with. So let's keep in mind the rules that we've already gone through, right? The rules for personal knowledge, for competence, for opinion, all those things that deal with the quality of a witness's testimony. And now let's add to that, okay? 607 says, who may impeach? Anybody. Right?
You can impeach your own witness? Well, why, yes.
607 says any party can, right? Can you think of a reason why you might want to impeach your own witness?
Can you say something that hurts you?
Maybe. Yeah. Maybe. But what do you think the most common reason is you impeach your own witness?
Change their mind or the story?
They might do that, but the biggest reason you want to impeach your own witness is so the other side doesn't, right? If they've got all this great stuff that you know they're going to use, you use it. You soften the blow, and then when they come up and they try to do it, the jury's we've already heard this.
And that does a couple things. One is, it's easier if you bring it out first, right? Right? Because the jury, you can phrase it, explain it, put it in some context. But the other thing is, you want the jury to believe you're the one that's telling the truth. You're not trying to hide anything. You're laying it all out for them, right? The other side is trying to hide stuff, not you. So if you have a witness and you got some bad stuff, bring it out. It's going to come out anyway. And so the jury feels like, yep, I can trust Pete Nolan, because he had some bad stuff about that witness, his witness that he wants me to believe. And he brought it out. So he gave me the full picture.
And I can tell you, this is just a perfect example. In all of my trials, in all my experience, witnesses come across either believable or not, right? When you're listening to them, they either resonate as coming across truthful or not. They just do. That's just the way it happens. And it doesn't matter what they look like or how they dress or anything like that. And it was always my preference whenever I was using an informant, I brought them into court in their jumpsuit and with their chains, just like any other inmate. Now, I could have gone to the court and got an order to have them dressed to come and testify, and you put a little suit on them, and then they come up, and it's going to come out, you're in jail, aren't you? Right? You're a gang member, aren't you? You cut a deal, haven't you? Right? And it doesn't matter what they look like. If their story comes across credible and it resonates with what the juror's experience is, they're going to believe it regardless of that. And most jurors appreciate it. And then what happens is they look over at the defendant sitting there in their suit. And for some reason, all defendants wear glasses now, right? They put their glasses on and they think it makes them look softer. I don't know. But it puts that little thought in their head. Like, wait a second, you're trying to pull one over on us. And I don't have to say that because I say it about my witness. Look, I'm not trying to pull one over on you, dressing up my witness like somebody else. Look, he's a gangbanger, he's a criminal, he's in jail, and here's who he is. But listen to what he said. And they say, oh yeah, I believe him, right? And just talking about that puts they now draw the conclusion on their own. Yeah, somebody else is dressing up other people. Okay? So sometimes you want to impeach your own witness so it comes out on your terms, not on somebody else's terms. Okay? 608, a witness's character for truthfulness or untruthfulness. This is still character evidence. It can only be attacked or supported by reputation and opinion evidence. That's it.
So what can it be? What can't you do? Specific act.
You guys hear that? No specific act for truthfulness or untruthfulness. Okay, and it can only come in once somebody's character for truthfulness has been attacked.
Which means you don't get to bolster your witness with people saying, oh, they have a reputation for being truthful, or I know them and they're truthful, they got a good character for truthfulness, until somebody challenges their character for truthfulness.
Okay, so once it's challenged, you've got a character for being untruthful, you can come back with testimony about your truthful character. You can cross-examine opinion testimony with specific act questions, but you don't get to bring in the specific act evidence. Okay? So, except for a criminal conviction, this is B, 608B, except for criminal convictions under Rule 609, which we'll get to that. Extrinsic evidence is not admissible to prove specific instances of witnesses' conduct in order to attack or support their character for truthfulness. But the court may, on cross-examination, allow them to be inquired into if they are probative of the character for truthfulness or untruthfulness of, here's the distinction here, the witness or another witness whose character the witness being cross-examined has testified about. So you can challenge, okay, I take the witness stand and I say that witness right there, they've got a character for being untruthful. Okay? So you can then bring somebody up to say, well, I know him, and that witness has a character for being truthful. And you can say, that's it. One attacks first, you respond in kind. But if you've got a witness on the stand, and that witness is taking a position, and they're saying, this person has a character for truthfulness. I've known him my whole life. I've never known him to lie. They're always telling the truth, and in my opinion, their character for truthfulness is unblemished. Okay, you can then ask them, well, do you remember that time that he was contacted, at school, and he lied and he said that wasn't him or whatnot? If you have those specific instances, you can challenge them with that. Or under one, you can challenge that witness. Well, remember that time you lied? You can ask them about specific acts of untruthfulness of the witness that's testifying. Okay? But you can only do that if they're a truthfulness character witness. Okay? That's an important distinction. You guys understand that? Seeing blanks? I'm not seeing nods yet. Oh yeah, we get this. One more time.
So if a witness gets on the witness stand and testifies about the truthfulness of another witness, then the rules are different. Then you can ask specific act evidence about that witness and that witness's truthfulness and the other witness that they were talking about.
Okay, but only if the court allows you to. So that tells you what do you have to do first. Run it by the court. Don't start calling everybody in the courtroom a liar unless the court has given you permission to challenge them. You're going to know before they ever take a stand that they are there to talk about somebody's truthfulness. Okay, once they do that, then you tell the court, well, if they do, I want to impeach them with this. I want to hit them with this. And the judge will say yes or no. Okay. But understand that with the character for truthfulness, there is no other specific acts that allows it in for motive or knowledge or anything like that. It's only opinion and reputation, and only once it's been attacked first. Okay? So, 609 can be messy. So let's walk through it and let's pay some attention to it. Okay? This is impeachment by evidence of a criminal conviction. Okay?
And why they make it so hard, I have no idea. But they do.
They do.
And recognize that the state rules are different.
And it's funny because we always fight to get it in. right? Somebody's got felony convictions, you're arguing, I want it to come in, and the other side's arguing they want it out. They want them in on your witnesses, they want it out on theirs, and it's very rare. I never really came across it where attorneys really argue it, right? It's rare that you stand up in front of the jury and say, don't believe this person because they're a convicted felon. I know I never did it, and there were very few defense attorneys that I tried cases with that ever stood up and really made an argument, said, don't believe them because they're a convicted felon. The judge will give them an instruction that says, this is one of the things you can consider, but they don't really do that. Okay? So in general, the following rules apply to attacking a witness's character for truthfulness by evidence of a criminal conviction. 1, for a crime that in the convicting jurisdiction was punishable by death or imprisonment for more than a year. Here's what you have to understand. In California, we spell it out. We say a felony and a misdemeanor. Okay, in federal rules, they don't do that. Okay, if they say punishment by imprisonment for more than a year or death, just think in your mind, we're talking felony. It doesn't say felony here. Okay, but just realize that.
But conveniently enough, misdemeanors in California can't be punished by more than a year in county jail. So it sort of lines up with how we divide things here.
Okay, so notice it says the convicting jurisdiction was punishable. So if it's not a California case, where were they convicted at? Doesn't matter, pick a place. Right, Florida. All right, in Florida, what could they have been punished for? 18 months. Okay, then it qualifies. All right, it doesn't say what they did get punished to.
Right. Very important distinction.
Okay, it says that the crime was punishable by death or more than a year.
So what's the maximum punishment? Sometimes this requires you to do some research, right?
So look at that. You got to look at the language of what they were convicted of, not what they actually served for A1. So A1A, it says it must be admitted subject to Rule 403 in a civil case or a criminal case in which the witness is not a defendant. Okay, so civil, criminal case, doesn't matter unless we're talking about the defendant. You got somebody with a, let's just call it a felony conviction. The rule says it must be admitted subject to 403.
403, yeah.
Right? So if you want it in, Your Honor, the statute said it must be admitted. And the other side says, well, Your Honor, under 403, it's too prejudicial, we shouldn't let it in. That's how that plays out. So why does this say subject to 403? Right? Every other rule, we do a 403 analysis, right? Why does this one specifically say 403? Why do you think?
Because of the language that says must be admitted. So it's like mandatory, and the other ones are like, maybe it'll be admitted.
Not necessarily. Let's look at B, right? Must be admitted in a criminal case in which the witness is a defendant if the probative value outweighs its prejudicial effect to that defendant.
So compare that language to 403. What's missing?
Substantially.
Yeah. So it's a different standard for the defendant. For the defendant, you just weigh probative value, prejudicial effect.
Okay.
The prejudicial effect doesn't have to substantially outweigh the probative value. It just has to outweigh it.
So they put that there
Big difference.
for two reasons. Number one, because they want the court making sure it's doing a balancing, right? But number two, to draw the distinction between the types of balancing it wants the court to do.
And why would you want to do that with a defendant's criminal conviction? Why have we got a different standard for defendants?
Because the jury will convict them on their past crimes.
Because we're trying to be fair to defendants, right? And so we have a rule that says, forget that substantially outweighs the probative value, right? Just compare prejudicial effect, probative value.
Right. And notice the sides, right? 403, right? It comes in unless its probative value is substantially outweighed by the prejudicial impact. So which weighs more? The prejudicial impact. And B, you want to use it against a defendant? Its probative value actually has to outweigh its prejudicial impact. Right? If you want to in, it better be very probative. Okay? So,
And by the way, the prejudicial effect of a conviction of the defendant is always pretty goddamn prejudicial.
Yeah.
Okay?
for just your reason.
Yeah.
You know? And everybody knows it. As soon as they hear he's guilty, he's
already
been
been
guilty of
convicted.
something before, yeah, he's done. Right. So for felonies, those are your two rules. And civil or criminal case for a non-defendant, 403 balancing. Okay, in a criminal case for the defendant, you've got to do that special balancing. So make sure you have that distinction down when we're talking about it, because you may get screwed up.
It is easy to get confused about this, right? So who's the witness? First of all, if it's a civil case, right? It's always the same standard. Doesn't matter what witness you're involved. In a criminal case, is the witness the defendant? Then we got the special rule.
So sub 2, for any crime, regardless of the punishment, the evidence must be admitted if the court can readily determine that the establishing the elements of the crime required proving or the witness admitting a dishonest act or false statement. So if you want to get in, let's just say a misdemeanor, right? Because this says regardless of punishment, where the other one said anything from over a year to death, has these rules. This says for everything else, you got to look to the elements of the crime. And can you establish from the elements of the crime that it involves a dishonest act or a false statement?
Usually this is pretty easy, right? A dishonest act, and there's lots of things that that you wouldn't necessarily say, oh, that's a dishonest act. But literally there's a book by Justice Simons that, at least for California cases, lists lots and lots of crimes, and whether they are what's called a crime of moral turpitude, dishonest act, or not. Simple drug possession is not. Possession for the purpose of sales is, things like that. So usually it's pretty easy to tell. Almost always there's going to be some authority, at least for California cases, about whether something is a crime of moral turpitude that involve a dishonest act or not.
So for us, it's easy. If you're in federal court, you know, not so easy. In California, you always got a case on point.
And where this list comes into play is if you've got a misdemeanor, is that a misdemeanor, especially after Prop 42, is that misdemeanor a crime of moral turpitude or not? And so that's real helpful to know that there is such a list in some reference book.
So notice there is not that requirement for dishonesty or false statements for the first one.
felonies.
If it's a felony, doesn't matter what it is, doesn't have to have an element of dishonesty. You know, it's just,
And remember to forget this distinction when you litigate in California state court. Okay, just FYI, our rule in state court about the admissibility of prior convictions doesn't turn on, well, it's any felony. It's still got to be a crime of moral turpitude to get in state court. Okay, now I've talked enough about state court. Good. Just remember, the rule isn't the same as the federal rule.
so, you guys get that? Yes, nods,
Yeah.
smiles.
So just to recap, it's a felony, right? It's a felony. Any witness other than the defendant, what do? 403 balancing, right? Defendant, probative value versus prejudicial effect, and we're not tipping the scales either way. Defendant in a criminal case. Misdemeanor, gotta be a crime of moral turpitude.
All right. B, limit on using the evidence after 10 years. Well, that seems easy.
Oh,
enough.
wait a minute.
That seems easy.
Now we're gonna throw in a time clock?
You know, this subdivision B applies if more than 10 years have passed since the witness's conviction or release from confinement for it, whichever is later.
Of course, thank you.
Evidence of this conviction is admissible only if, and we'll get to 1 and 2, but do you understand that first part? It's 10 years calculated from the date of conviction or the date of release, whichever is later. And if you got a felony,
It's always gonna be the date of release.
it's probably going to be the date of release, unless they got no custody on their felony.
In which case, it's the same time.
Right? Then you go by date of conviction. So somebody is convicted, right? In 2005, they do 10 years. You're thinking, well, that's easy. 10 years, they get out in 2015. No, because we give them a bunch of credits, right? They get 10 years. They probably actually serve 3 years.
Oh, now it's getting close to being 10 years.
Right? And now they're out in 2008. Okay.
Or they
And
just got released early, right?
Yeah.
This is, especially in California under, what was it, Prop 57 or whatever. This gets really complicated because, yep, you got convicted, you got a prison sentence, you got the upper term of 5 years, you got 3 one-year prison priors, you're gonna get 8 years. Oh, the 1-year prison priors went away because the Department of Corrections decided to kick them out early, and they were getting day-for-day credits, and so they actually served 2.5 years, but they had credits from before their conviction, and so they really got out 18 months after the conviction. Like, what the hell? They got an 8-year sentence. What do you mean they got out in 18 months? So it may require some work to figure out exactly when that release date is.
Okay. But here's the good news. This information has to be given to you. Right? If we want you to answer this question,
Yeah, we will get
right, we've got to tell you.
That is not the good news in the real world.
They were convicted of this crime on this date. They were sentenced to this amount of jail time. They were released on this date. Because just giving you how much they were sentenced to is meaningless.
Yeah. So that's the good news for the limited purpose of taking an exam in evidence class. In the real world, you're going to have to do some sleuthing to figure out exactly when they got released.
Okay, so now here's the rules. Assuming you're within 10 years, okay, either from the date of conviction or date of release, it hasn't been 10 years. If it hasn't been 10 years, then it's only admissible if, number one, its probative value supported by specific facts and circumstances substantially outweighs its prejudicial effect. And notice there's an and, but let's focus on this right here. Its probative value supported by specific facts and circumstances substantially outweighs its prejudicial effect. That's even farther than the defendant in a criminal case, right? It's even harder to get it, right? So if you want to use a felony conviction, 403. You want to use it against the defendant, well, it's going to get a little bit harder for you. You want to use it against any witness, and this thing's 10 years old. Well, its probative value has to substantially outweigh. And what does it need? Specific facts and circumstances. You don't get to say, Your Honor, this is really probative. You say, okay,
Why?
why? You have to articulate your facts and circumstances that you're relying on to demonstrate that it's probative. Okay, and 2, the proponent gives the adverse party reasonable written notice of the intent to use it so that the party has a fair opportunity to contest its use. Again, that's part of the rule. It's an and, so that fact has to be given to you. And if it's not, then your analysis goes something along the lines, look, it's been 10 years. This guy was released on this date, 9 years, 364 days later. Its probative value is substantially outweighing its prejudicial fact due to this fact and this circumstance. However, the rule requires that reasonable notice be given, and we can't tell whether notice was given or not because the facts don't say that, right? If you have that, then goes towards your analysis. Okay? So just trying to picture, and hopefully this is making sense, it gets more and more difficult to try and use these things in your trial. And hopefully it makes sense, just like we know why it should be harder to use against a defendant, right? Because it is so prejudicial and it completely impacts their willingness to testify. You want to make sure a defendant doesn't testify in his own case, tell him all of his priors can be used against him. You know what? I've got a story to tell. I've got a version of events, but I know as soon as I take the witness stand and they hear I've done all these things in the past, my story doesn't matter. So I'm going to decide not to testify. Okay? And then what's everybody doing? Why didn't he testify?
They're not supposed to think about it.
Right? He's got something to hide. Right?
If he didn't do it, how come he doesn't get up there and say something?
Right. If it was me and somebody accused me, I'd get up there and tell them. Right? And we know juries think that way. And that's why the legislation makes it so difficult to use. And the older it is, okay, the harder it should be to use. Yeah, you did this. When did I do it? I did it 25 years ago. Okay, really? How probative is a 25-year-old conviction for, I don't know, drug possession, on whether you're telling the truth 25 years later?
And then you get this sort of, on that 10-year thing, you have this sort of messy thing of, well, he got released on parole, but then he effed up and got sent back for a parole violation. So now when is he released from custody? Right? It's when you finally get released. If you get sent back, it's when you finally get released. And by the way, that happens a lot in the real world.
So, under 10 years, all the rules of A and B apply. More than 10 years, sub B applies. Before it was sub A and B. Okay. Then let's just throw in some more into the equation.
Yeah, because it wasn't complicated.
Effect of a pardon, annulment, or certificate of rehabilitation. Evidence of a conviction is not admissible if the conviction has been the subject of a pardon, annulment, certificate of rehabilitation, or other equivalent procedure based on a finding that the person has been rehabilitated and the person has not been convicted of a later crime punishable by death or imprisonment for more than 1 year. So, if you've been pardoned, you've been rehabilitated, you've got this certificate, and basically all it says is that you've been rehabilitated and you've kept your nose clean, it can't be used against you. If you've been rehabilitated and you commit another felony, notice it says a later crime punishable by death or imprisonment by more than a year, and you've been convicted of it, well, then it can come in against you.
Which is really bizarre, right? I mean, think about this. The governor pardoned you, right? You can still have that conviction used against you if you commit another felony? That doesn't seem right at all, if that's what the rule is.
Or, notice 2 is an or. The conviction has been the subject of a pardon, annulment, or other equivalent procedure based on a finding of innocence. Much rarer,
Yeah,
But they're out.
that hardly ever happens.
but they're out there.
It does.
So if you have been determined to be innocent, it can never be used against you. Makes sense.
Which obviously makes sense.
Right?
yeah.
You were convicted of something, somebody later determined you to be innocent, can't be used against you. Right?
This rarely happens, but it does happen.
If you are
I've had a few of these where usually the defendant or defense counsel convinces the DA, hey, it was the wrong guy. It really, really was the wrong guy. And if you convince the DA that, then they'll like, okay. And then there's some paperwork and I have to sign my name like 15 times. And there's fingerprints and there's like all this kind of stuff. But if you can do that, you can get your conviction wiped out with an actual finding of innocence. But it doesn't happen very often.
Yeah, very, very difficult. If it's determined that you did the crime, but you've been rehabilitated, okay, well, then keep your nose clean. If you're truly rehabilitated, it can't be used against you. If you're really not rehabilitated and you've been convicted of another crime after that, then it can be. Right? Hopefully that distinction makes sense for you guys. All right.
But like I say, I think that's a little crazy because if you've been pardoned, you've been pardoned. That conviction's gone. But for this rule, it's not really gone because it can get resurrected if you commit a new felony.
And then you come to juvenile adjudications, right? Evidence of a juvenile adjudication is admissible under this rule only if it is offered in a criminal case, i.e. no civil case.
Okay.
The adjudication was of a witness other than
Not the
the
defendant.
defendant. So you gotta be a criminal case, and you can't use juvenile stuff against the defendant, only against other witnesses. And an adult's conviction for that offense would be admissible to attack the adult's credibility. And what does that mean? Everything we've talked about up till
Go back and
now.
look at the rules.
So you gotta go back to 609A and do all of that, right? Do your 403, do your 10-year analysis. Is there a pardon involved?
But in a sense, it's real easy because if it's a juvenile and you want to use it against the defendant, you can't. You just can't.
And admitting the evidence is necessary to fairly determine the guilt or innocence. That means this witness decides the case, right? This witness is so key. Whether you believe them or not, it is going to be a determinative on whether the defendant's guilty or not, right? If this is just some, sideline witness that doesn't play a big part, you're just not going to be able to use their juvenile stuff against them. Okay? So very hard to use juvenile convictions, and you can only use it on a witness in a criminal case. Nobody else. E, hopefully makes perfect sense. If you've been convicted and it's satisfied and you could otherwise use it against somebody, a conviction that satisfied this rule is admissible even if an appeal is pending, and evidence of the pendency is also admissible. right? I want to tell the jury you've been convicted of a felony. You want to tell the jury it's on appeal.
It's on appeal. And
Okay.
they can take it for what they want.
Yeah. So the jury hears both. You've been convicted and it's on appeal. Okay. And that is your criminal conviction. So after you've done all of that, right, then the jury may get to hear what? That you've been convicted of a crime, right? Remember, they may not hear what the crime was. They're not going to hear what the circumstances are. They're going to hear that you've been convicted of a crime. Period. Okay? And you then get to stand up at the end if you are so inclined, because the judge will tell them, how do you determine a witness's credibility? Look at all these things, all these factors. And one of those factors is, has the witness been convicted of a felony or a crime of moral turpitude, right? So you can stand up and you can tell the jury, don't believe this person. This is one of the factors. If it's the only factor you have, not a great factor, okay? Great factor if it's the defendant, not a great factor against other witnesses, okay? So, questions on the criminal convictions?
Could it be any more complicated?
There's a lot of analysis, and you just got to know the ins and outs of the rule. That's just, there's no way to get around it. And you got to know that there's different probative, prejudice, balancing factors in each different section. And you just got to know that and know what they are to accurately analyze whether a conviction comes in or not. Okay? 610, evidence of a witness's religious beliefs or opinions is not admissible to attack or support the witness's credibility. Okay, so somebody's on the witness stand, you don't get to say,
You don't believe in God, do you?
or we can believe you, right? Because you go to church every day, right? I don't know why you go every day, but
Hey, you want to make sure that your soul
You go-
is in a state of grace.
right, you're very religious, so we can trust you, right? You're not allowed to use
And twice on Sunday.
religions to support or detract from a witness's credibility. And it wasn't a witness, but I'll just tell you, I had a domestic violence case. It wasn't a difficult case, you know. The gal was beat up pretty good, and she gave good admissions and a good 911 call, and she predictably, you know, retracted and said, "Oh, I walked into a wall," or something silly. And that was your typical DV. And I had a Catholic priest on my jury panel. Came in his collar and everything. And I'm like, okay, do I want this guy on my jury or not? And I assumed, wrongfully, that he would be sympathetic to the victim. Right? He's going to hear this victim's testimony, and he's going to, not at all. Case hung 11-1.
Who was the one?
And he was the one. And he was all about the rehabilitation, and he thought that this guy deserved. He didn't think the guy was not guilty. He just thought he didn't deserve to be.
You know, which is, of course, not what you're supposed to
Yeah, I'm
consider.
like, why did I leave him on? Of course, then I never left anybody religious on any jury ever again. So 611, mode and order of examining witnesses. We've kind of already talked about this before, right? People, plaintiff, they go first, they call their witnesses, they direct them, the other side gets to cross-examine them. The key that we just want to kind of re-hit on here, specifically when it comes to impeachment, right? When you're cross-examining, the scope of your cross-examine should not be, it should be limited to those matters, the subject matter that was brought up on direct, and those matters that go to credibility. Okay, that should be your scope of cross-examination. That's the rule. In practical terms, it's cross-examination is expanded all the time, right? Just for convenience sake, for witness schedules, to keep things moving, right? Because if you limit it, then we're gonna have to call them back later, and it can be a mess. So generally speaking, the court may let you get into other areas, but just know that.
But ask.
Yeah.
Right? And if the plaintiff calls a witness to testify about 3 things, and you're the defendant and you want to cross-examine about 15 things, no. You're gonna have to call that witness back in your case. Because I'll let you disrupt the plaintiff's case a little, or the people's case a little, for the convenience of witnesses, and because I think jurors generally process information better if they can hear everything the witness has got to say in one sitting. But if the plaintiff wants to call the witness to only testify about a couple things, and the defense wants to get a day's worth of testimony about a bunch of other stuff, I'm sorry, I'm just not going to let you disrupt the plaintiff's case that way, or the people's case that way.
So if they start getting into stuff that you didn't get into, you can object. It's beyond the scope, but just know that, that they might be given some leeway on that.
And this is something that you may want to bring up with the judge outside the presence of the jury before the witness even starts to testify, right? Because if you know, for example, that the judge isn't going to limit you to those 3 things that you want to cover on direct and keep the rest for the defense's case, then that may affect how you handle your direct examination. So bring it up first, especially if you know the other side really wants you to testify about a whole bunch of stuff.
And sub C, leading questions. Okay, leading questions are really not to be used on that direct examination. They're to be used on cross-examination, and when you call a hostile witness an adverse party, or a witness identified with an adverse party. Okay, so that's when you get to use leading questions. Okay, and attorneys are really good at using leading questions. They're not good at the technique, and they don't really seem to understand the purpose. Right? When you're asking leading questions, you are trying to tell a story through your questioning. Right? When I'm cross-examining, it's my version of events that I am trying to get the witness to agree with or disagree with. And sometimes I don't care what their answer is, right? Because the question is what the jury is hearing. And, so you told DA that you were at the store at 7 o'clock. Isn't that true? Yeah, that's a leading question, but not really getting you anywhere. Okay, so most good trial attorneys will tell you, you ask short questions, very to the point, one fact, and you build your story. And if all you want them to do is just rehash what they've told the other side, sit down and don't ask any questions, because you're just reinforcing their story, right? Your cross-examination should be to get your story out there if you can. And if you don't know, most attorneys don't really seem to appreciate this, but you don't have to cross-examine every witness.
And in fact, if the witness really didn't hurt you that much, or testified about things that you really aren't disputing, sometimes an effective way to deal with that is, Mr. Witness, you understand that the key issue in this case was whether the defendant had the intent to kill the victim, right? And you just don't know anything about that, do you? Thank you.
Okay. It's okay to not cross-examine. Now, go over there and watch a couple trials, And you'll see, nope, they're gonna cross-examine every witness every time, and you're not gonna be impressed with any of it, right? Because it's just not, attorneys don't practice that skill.
It's way more effective to only cross-examine on the stuff that you absolutely need to bring that out and sit down, than to spend a bunch of time rehashing what was testified to on direct. And if it really didn't hurt you, maybe ask a couple questions to, clarify some points about why it really didn't hurt you. And sit down, right? And it sort of sends a message to the jury, I'm not worried about this guy, right?
And then lastly, let's just talk real quick about 613. Witness's prior statement. Okay, when examining a witness about the witness's prior statement, a party need not show it or disclose its contents to the witness, but the party must on request show it or disclose its contents to an adverse party's attorney. Okay, so that means you've got evidence that they've given a prior inconsistent statement. You don't necessarily have to show the witness, but you're gonna have to tell the other side. And then B, extrinsic evidence of a prior inconsistent statement is admissible only if the witness is given an opportunity to explain or deny the statement and an adverse party is given an opportunity to examine the witness about it, or if justice so requires. This subdivision B does not apply to an opposing party statement under Rule 801D2, which is you'll hear that comes into our hearsay rules. Okay, so if you want to offer evidence of a prior statement that is inconsistent with what their testimony is, you got to confront them with it. You've got to give them an opportunity to explain it, to deny it, and then you've got to give the adverse party an opportunity to examine the witness on it. Okay, it doesn't mean they have to examine them, but they have to have an opportunity to examine them. And then if you've done those things, then the court may allow you to bring in evidence of that inconsistent statement. And generally that's another witness who's going to come in and say, they told me this. Okay. So that's a common tool of impeachment if you have it, but just know that don't oversell your hand, right? Just because somebody said one thing in one interview and they're saying something different on the stand does not necessarily make them a liar. Right? It could just be that they're misremembering, or what they're saying isn't all that inconsistent. Right? And you need to draw that conclusion for yourself. Right? If somebody testified previously that they saw the getaway car was a dark blue van, and then on the witness stand they say, well, yeah, I saw the getaway and it was a black van. Okay, is that an inconsistent statement? Yes. Is it a big inconsistency? That's for the jury to decide. If I'm on a jury, I don't see that as that big of a deal, right? But if they said, it was a white sedan, okay, that's pretty different. That's a big deal. Wait a second, you said it was a dark blue van, and now you're saying it's a white sedan. Something's changed here, right? You're definitely going to want to point that out to the jury to demonstrate that their current testimony can't be relied on. Okay? So just because somebody has said something differently in the past does not necessarily mean you're going to want to impeach them with it. You've got to evaluate whether it is a worthwhile endeavor on your part to discredit the witness. Okay? Let's go through a couple of problems here. Let's see. Okay, let's get into chapter 7. Why don't we start with 714 on page 268. Okay. Who wants to jump up there?
I'll start.
Okay.
Jim Stone is sued by his neighbor for the conversion of his neighbor's very expensive Cannondale bicycle, which disappeared at around 11:45 a.m. At trial, Jim testifies on his own behalf, claiming misidentification. Jim offered an alibi. He asserted that he was at work several miles away from 9 a.m. to noon, including a time when the alleged theft occurred. On direct examination, Jim stated, "If someone took that fancy bicycle of yours, I'm really sorry, but I can tell you this. I was at work several miles away from 9 a.m. until noon on that day." On cross-examination, Jim is questioned as follows. Plaintiff's attorney: "Isn't it true that on the day in question, you work in the morning from 9 a.m. to 11:25 a.m. and not to noon as you just testified?" Plaintiff's attorney: "Objection, irrelevant. How should the judge rule? Why?"
Okay, so the objection is relevant.
Right.
Right, that's the only objection.
So judge should rule. It's highly relevant in this case. It's relevant.
Of course it's relevant.
Yeah.
It has a tendency to prove a fact
Was it there until-
of significance or disprove.
This is his alibi. Right? It's like the main issue in the case.
Plaintiff's attorney: "Are you going to lose your job if you're found liable in this case?" Defense attorney: "Objection. On what grounds and what type of impeachment is occurring? Explain." You're going to lose your job. It's irrelevant.
Is it?
No, what objection would you make? Relevant?
Yeah, relevance.
Okay, explain why that wouldn't be, why that's irrelevant.
Oh, sorry.
Might that not go to bias somehow and show that the witness has got a reason to shade the truth or just flat out lie? Not just he might lose the lawsuit, but he might lose his job too, right?
So it's unbiased.
So that's one possible ground is relevance, right?
So if you're the defense attorney, right? Objection, and it says on what grounds, right? Can you think of grounds that the defense might object? Right, they might say irrelevant, right, whether he loses his job or not. But then plaintiff counsel is going to say, yeah, but this goes to his bias and interest in the case. Right? He's got an interest in the outcome. And now you're the judge and you say?
Was sustained.
Say what?
Objection sustained.
Okay, so that means the answer does not come in.
Right.
Okay.
So am I wrong?
No, look.
I have a question. I don't understand why it's biased.
Because it shows that the witness has a reason to shade or even flat out lie. Not just he might lose the lawsuit, right? but there might be even worse consequences or more consequences.
For answering that question, because the plaintiff's attorney is the one asking it, so that's why if it's to impeach the witness that's on the stand and the witness is the defendant, how is that question? Is the question biased? I guess I'm just confused about
The
that.
question is trying to demonstrate that the defendant has a personal interest in the outcome of this case.
And not just,
I.e.,
he might lose the lawsuit.
right? He wants to demonstrate you got a reason to lie here. We can't trust you, jury. Don't trust him. Why would he lie? Well, because he's going to lose his job out of it.
It's not just you might have to lose the value of the bicycle.
You see, because he's got, when somebody has a personal interest in the outcome of the case, they're arguably biased in that case, right? They want it to go one way or the other, right?
And you might say, well, the defendant, of course, has an interest in the case, because if the defendant loses the case, the defendant's going to have to pay for the bicycle, right?
And
But
that's why you want to demonstrate something more than that.
Yeah.
And that's what this tries to go to.
Maybe the bicycle is worth, I don't know, they tell us how much the bicycle is worth?
This is very nice.
Okay, so maybe the bicycle's worth $5,000, right?
Fancy.
Okay, so the bicycle's worth $5,000, the defendant loses, he's gonna have to come up with $5,000. Oh, but he might also lose his job, and maybe he makes like $10,000 a month. Well, crap, that's an even bigger reason to lie, right? Much bigger reason.
And so just imagine anybody else on the stand, right? His girlfriend, right? His mom, right? His best friend, right? They all have an interest in the case. They all don't want to see their loved one lose his case, whether it's just going to cost him for the bike, or as this question suggests, something more. You got more of a motive to lie than just losing his case, because you'll lose your job too. Right? If you're convicted of this crime of stealing the bike, you could spend the rest of your life in prison, couldn't you? Right? That you don't do that in criminal cases, because it's just kind of implied. But you see the point, right? If you can demonstrate that they've got a personal interest in the outcome of the case, it opens you up to the argument that they're biased.
And it's not just some interest, it's the significance of that interest, right? The value of the bike may not be all that big a deal. The loss of the job may be a very big deal. That's why it goes to bias and gives it and shows that the witness might not be telling the truth.
Right? I would probably overrule it and let it in. But you're the judge, right? But you just, if you're going to sustain it, you have to articulate why, right? And that's where, as long as you can do that and show us your thought process, I think this is a collateral matter. I don't think it necessarily shows the bias that it infers, and I'm going to sustain the objection. And just make sure you articulate how you get to that conclusion.
Okay. Next one, weren't you convicted of felony the distribution of marijuana 3 years ago? Objection, what grounds? On prior convictions. Is this regarding the like a party or enrollment?
Where's there a reference to a party or enrollment?
Mm-hmm.
There isn't. do we even know if this is a felony or punishable by at least a year in imprisonment?
No. This is distribution of marijuana.
And what does the rule require for you to ask this question? It's a civil case, a civil defendant. How does it come in? Right, it's within 10 years. So it's presumptively admissible. Right? The rule says it must be admitted unless
its probative value is substantial outright.
And so your objection is irrelevant, not that probative, highly prejudicial, right? Now, you want to argue your grounds that match the rule that lets this in or out.
Yeah.
Right?
Right.
And clearly this is something that should have been discussed. You're using language that the rule doesn't allow. Right? You're saying felony. Do you get to say felony? No. Like his honor said, well, how do you know it's a felony? You're just saying that, but how do you know? And what is he saying? Felony for what? Marijuana. Do you get, assuming you get to use the conviction, do you get to say what the conviction is for? No. This plaintiff's trying to do that. Right, so you could object to, right, the specificity of the conviction, right? Because this jury really hates marijuana, and so.
I have a question.
Okay.
So they only need to know that you're convicted of a felony, you don't tell them what they're convicted of, then, right? They don't need to know what you're convicted of.
Right.
Okay.
And it depends. Sometimes it doesn't matter. Like, let's say it is marijuana. It's a marijuana crime. Maybe you want that in, right? Maybe you want to say it's legal now. That's not even a big deal. I want them to know that it's just marijuana. Okay. And then the other side is going to say, no, I just want the conviction. I don't want them to know what it was for. And so maybe you flip hats. And
Except seriously, if you're gonna bring it up and try to impeach, you know that the other side's gonna say, and what was that conviction for? Right, so.
but remember, we old crow. Remember the prosecution wanted in this fact that this person was a felon with of assault and robbery and all his other violent felonies, and he was like, I'll stipulate, you know, that I couldn't have possession of that. Right, so it depends on what the felony is. The judge a lot of times will tell you, no, I'm not letting you get into what the felony is. Right? Marijuana is not as serious. What were you convicted of? Child molestation. Oh, forget about it, right? Yeah, you're never getting that in. Right, of course that's prejudicial.
I'm questioning that, but you know, the damage is already done. The jury does find out if he asks this question. Then the jury knows, right? And even if you move to strike it, whatever, they know. So
That's why you better bring this up, right, in pretrial, because if you, every trial I ever did, we always talked about every witness and all of their convictions. Always.
Very common.
Because of just this reason. Because once you say it, you can't undo it. Right? So.
And if you surprise a judge with that question, you're gonna regret it.
Yeah. So that's just kind of, it's just one of those areas. Okay, we've exchanged witness lists. Any impeachment issues on any of these people we need to worry about, and you'll know. Yeah, I got nothing on these. I got some on these, and and you talk about it, and you literally go witness by witness. What do you got on each one? What do you want to use? And then going in. Here's what I can use on this person. Here's what they can use on that person, and there's no surprises. So.
You cheated on your law school admission test last year, didn't you? Objection, I would say relevant.
What kind of evidence is this?
Oh, okay,
It's specific act evidence,
so,
right? So are you gonna be able to use that?
no,
Only in extremely limited circumstances when this is a character witness to the truthfulness of another witness and that other witness's truthfulness has been challenged, right? Do we have any of that stuff? No. So it's not just relevance, right?
Next, you have intermittent amnesia, Mr. Stone, don't you?
There's an objection to that?
Objection.
How are you gonna object to that? You got problems remembering stuff. Can anybody think of an objection to that question that might remotely have a chance of being sustained?
It'd
What if? Okay.
be inability to remember.
Right, well, that's what that's inferring.
Yeah.
What if it's not true?
And if there's no good faith basis for asking that question.
You're just asking that, you know, and you're leaving that impression. He's like, no, I have no idea what you're talking about. Right?
That's because you have intermittent amnesia. You don't remember.
Right? So that's one of those things too that let's assume you do. Nothing objectionable to bringing that out and impeaching him with it.
But there better be some
You've gotta-
reason for you to ask.
Remember on cross-examination, when you're asking these pointed questions, you've got to have a basis, right? You cheated on your LSAT. Let's assume there's nothing to that. You're just creating that out of thin air. Totally inappropriate. And even whether it comes in or not, you can't just make stuff up,
Well, it might be true. I
Right?
don't know. Maybe you cheated on his LSAT.
right? You've got to be able to point to some basis to justify you asking that question. Okay? And it doesn't have to be a strong one, right? You talk to Mr. Stone's, boss. He says, yeah, I think this guy's got like intermittent amnesia or something. You know, he's had memory issues.
Because half the time I don't know anything.
You know, and okay, is that enough to ask a question? Probably enough. If you challenge me, I've got a witness who can come up and say, now, is he a doctor? Can he give that diagnosis? No. But does that justify you asking the question? Maybe, right? Because where did he get it from? Why would he just diagnose this guy with that without anything? Right? He was probably told that at some point. Maybe by the defendant himself. No. Okay, right?
Didn't you say in your deposition on June 5th that you drove to work via Parkway, not US 1, as you just testified? Can you object? Must.
Well, they're trying to hit him with a prior inconsistent statement, right?
Right.
In your deposition, you said you get to work on the Parkway. Now you're saying you get to work on US 1. Which is it, liar? Right? You can't make up your mind, can you? You don't know how you get to work. Yeah, you want this jury to believe you didn't steal his bike. Right, so that's one of those where, let's say that's a big deal, the Parkway comes in this way and US 1 comes in this way. Okay, maybe. What if US 1 is called the Parkway by the locals? Right? Maybe it's not all that significant, right? Is it do you get to impeach with prior inconsistent statements? Yes. Right? If you give them an opportunity to deny and explain it, and he's keep doing that, kind of. Didn't you say this? Yes. Let's say his answer is yes. And then you move on to something else. Have you given him an opportunity to explain that answer? You haven't, right? Now you've given him an opportunity to deny, you have not given him an opportunity to explain. Okay, so if you want to use the prior inconsistent later on, you want to be able to call that other witness, you want to offer that extrinsic evidence, you've got to give him the opportunity to deny and explain, which means you've got to ask that follow-up question, well, how do you explain those discrepancies? Now, assuming he says, yes, I've said both of those things. If he denies it, no, I didn't say that in my deposition. Okay, well then there's no explaining. You're denying that you even said that, and you can move on. If he admits, yeah, I said that, well, explain. What's the discrepancy? And hear what he says. Right? You've given him that opportunity, and at that point, it really doesn't matter what he says because your argument's going to be that he can't be trusted. He can't get his facts straight. Right? He's a freaking doper. He uses marijuana. And he can't remember all that stuff because he's got this amnesia, and you can't trust anything he's saying. And even if he does remember some of the facts, well, he's a liar, a cheat, cheats on his LSAT. Right? Right? You're trying to just hit him on a little bit of everything there. Okay? Your objections, remember, if you're the party objecting, try to use the rules by which you're objecting. Right? And try to use what's required in those rules to do that.
And remember 403, undue consumption of time. Right? Don't forget that one because judges tend to think that you're always unduly consuming time.
All right, who wants to do 715?
Carolyn testified in a commercial litigation action. Which of the following questions are permissible during the cross-examination of Carolyn? Explain. 1. You used your personal computer to make notes of the meeting with the opposing party only 2 days after the meeting occurred, not immediately thereafter as you testified on direct examination. Isn't that right? So this would be a prior inconsistent statement.
What statement is it referred to?
That when she used her.
Yeah, but what statement? There's no reference to a statement. Right?
Mm.
So is that a valid question?
But it says that she testified on direct.
Right. But this is different than what she testified on direct.
Oh, okay.
But you're not referring to some different statement. You're just saying that statement that you said on direct is not true. Right?
Okay.
So is that an appropriate question?
Yeah.
Yeah,
Sure.
why not?
Assuming
That
you've got
basis
you've
for-
got evidence that she used a personal computer, 2 days after it had occurred. If you don't, and you're just making that up,
Yeah, then it would.
and right. But assuming you've got a witness that's going to say that, then yeah.
Or some evidence, right? It could be that you got the notes produced to you in discovery and you note that in the metadata, it shows that the document was created 2 days afterwards, right? So it doesn't have to be some witness. It could be a document, and any basis for asking that question.
Okay. 2, you have a Macintosh computer, not a Dell, as you just testified on direct. Isn't that correct? So would this be the same situation?
Kind of the same thing.
Maybe, is it relevant?
Yeah, who cares?
Yeah.
Really? Really? Maybe, I don't know.
And that's what I'm saying, it's just a big point. If it's not a big point, back to His Honor's point, you're wasting time, right? Why are we going through this if it's not an important point, right? What if it is? Right, maybe the type of computer mattered, right?
3, you left your office last Wednesday at 5:30 PM, not 7:30 PM, as you testified on direct examination, right? So this is a valid question because maybe the timing would be important.
If it's important for some reason, sure.
4, your boss, Ms. Sanders, was wrong when she testified that she deposited the March proceeds on March 4th. Wasn't she? I wouldn't say this is a valid question because it's somebody else's action, it's not her own.
So, another witness gave testimony that's inaccurate. Can you ask about that? Why not? Where you have to be careful is asking witness 1 to call witness 2 a liar, or the other way around, right? That's where you have problems, because that's an argumentative question, and we don't generally let one witness call another witness a liar. But if it's just that testimony that you heard from another witness was inaccurate, and the real version is, whatever, absolutely. Witnesses often don't remember things that remember things differently.
And here's the important thing to remember. If you look at the commentary right above this problem, right? When you're seeking to contradict somebody, right? You just testified to this, but isn't this actually true? Okay. As a general rule, unless the court deems the response, important to the outcome of the case, you're stuck with that witness's answer. Like, isn't this true? Nope, not true. Well, you don't get to prove that it is true unless the court says this is important.
So, if this is an important fact, right, you can ask witness number 2, well, what about this, right?
Otherwise, you're stuck with the answer.
Would personal knowledge have any relevance to it because she's not the one that testified to it?
Well, what makes you think she doesn't have personal knowledge of it? What's the question that's being asked of the witness on the stand now?
And she was wrong when she testified, not
No,
that.
no, what's the question? Read it.
Her boss, Ms. Sanders, was wrong when she testified that she deposited the March proceeds on March 4th, wasn't she?
Right, okay, so absolutely, you could object lack of foundation. How does this witness know about the deposit? Right, yeah, absolutely. Because if this witness doesn't have personal knowledge of the deposit, then,
5, isn't it true that you are one big liar?
that sounds argumentative just a little bit,
Just a tad.
maybe.
You got me.
Ah,
You got me.
I never thought you'd ask me that.
All right.
That's a classic argumentative question.
You guys want to take a break real quick, come back to a few more problems and get the heck out of here. All right, great time. Well, thank you, thank you.
So you heard I'm going back to civil, right?
I did.
So, I'm not doing the biz orders class. I'm gonna do, second semester of this class. But I'm gonna reevaluate it at the end of the semester and see if I wanna do this again, because I'm not coming to Indio.
Yeah.
And I'm just gonna be a lot more work than what I've been doing.
So I can tell you it's, and I haven't shared this with you, but yeah, I've just been thinking, it's just because I live in Palm Springs. So-
Yeah.
And it's easy when you're right here.
No, if I'm, half a mile down the street, well,
Yeah.
that's not a problem.
Yeah.
But if I'm like making a special trip, and your office is in Palm Springs, right? So if I'm making a special trip to come down here to teach, and I've got to do stuff like tentative rulings and, read, whatever, anyway. So we'll see how it plays out. It's entirely possible by the end of the semester, I'm like, well, it wasn't as bad as I thought, or whatever. But I really don't want to come here 2 nights a week when I don't, so that's why I said I'm not doing the biz orgs, because it's just, it's too much. So we'll see.
Yeah. I get it.
And then I gotta look at the conflict rules. I think I can hear your firm's cases, but not your cases. I think. But I'm gonna check it out.
I've got, good cases.
They don't get filed.
Yeah, all right.
But I stay late night. It's funny because it does just take experience, For example, I had a motion coming out of Riverside, and that was on court call, and it was the first time this had come across my desk. We got the tentative ruling, and on the tentative ruling, it said, if you want to make oral arguments, you gotta
Notify us and the other side, right?
I saw it, and I didn't really think about it. It wasn't something I wanted to argue, because I was kind of a side party to this particular issue. And Judge said, okay, everybody got my tentative, and somebody said, well, you're not gonna be first on that.
Did anybody request argument?
And another person said, nobody requested argument, and the judge just shut down. And
Never suggest anything worse.
When you we're taking a break. When you were doing civil and nobody requested oral argument, but people showed up anyway, did you let them argue? Yeah, there you go.
Yeah.
There you go.
So I just had that experience where,
Asbury?
no, somebody in Riverside.
No, Asbury's in Riverside.
Yeah.
But I guess it's not
No,
right.
it's not. And they said, somebody tried to argue, and one of the other parties, there's like 6 parties in this case, and I didn't have a dog in this fight. And so we said, Your Honor, they haven't given notice, and the judge said, yeah, you're right, nobody gave notice, so we're done. And
And then 9 times out of 10, I would do that. I had a really close friend of mine, Jim Packer, showed up. And I said, Mr. Packer, did you request argument? He goes, no, I didn't, Your Honor. And we did this out here in the desert before they did it in Riverside. We
Oh,
did it in
okay.
the desert for a decade. And he goes, I didn't know that rule. I go, well, that's the rule. And he's a professional. He says, thank you very much. And he accepted your tentative rule and he walked out.
Mhm.
Yeah. So, yeah, typically, but sometimes you get someone that's, they're way out, they just don't know what's going on, or a poker, or sometimes I could say, I'll let you make a record, but the tentative stands. But usually we have the rules.
Yeah.
Oh,
Yeah. And occasionally somebody would have a good reason for it.
yeah, it happens.
But then
I called Barbara Berg, Your Honor.
And I'll tell you, the significance of the motion matters too.
Yes.
If it's a big motion, gonna make a big difference in the case, I'm probably gonna cut you some slack and let you argue. I may not change my mind.
Right.
He's my
But what I really liked was then the judge said, okay, the moving part is like, you'll give notice to everybody? Yep, I'll give notice. And today I got in the mail a notice of the ruling, and it was the tentative attached to.
Yep.
That was it. It said, here's notice, and here's a tentative attachment.
Yeah.
So prevailing party to give notice.
But it was the entire tentative sheet, which had multiple cases
Oh.
on it. He did,
That's
and he just literally
He's a
just
little lazy.
attached it. Okay, well, there's my notice.
Yeah, that is a little.
So it's just, it's these little procedural quirks that are,
And that's a local court, that's
mm,
not the law. Okay, it's a local deal. You know, I was in San Francisco and I thought I was getting back to the office, or the plane got delayed and I didn't have the number, I couldn't call in time. I called the other council and told them that I was getting the argument or something. Yeah, you never know.
mhm.
There's always something. Attorneys pretty much never will.
Yeah.
But it is fascinating. I mean, you really get, your whole horizon is being expanded by some of this stuff.
Oh, yeah. We went, I met with a potential client and he told me all his issues and it seemed like there was something there. I came back, I talked to one partner, explained it to him, he said, yeah, this sounds good. Here's how we might work out a fee arrangement on something like that. Talked to a couple other partners, they said, yeah. So I sent off an email, here's our thoughts and here's what we can do this case for. Nobody told me boo about anything. Next day, there was one holdout. It was subject to Tom Slovak's approval. Slovak came in and said, hey, talk to me about this case. I told him about it. I had had the same conversation with the other partner and they never said a thing. And it involved an architect. I said, well, who's your expert? We don't have one yet.
Why are you taking the case?
Exactly. Where's your, you gotta, you're gonna need a certificate of merit, you're gonna need this, you're gonna need that, and this is all by rule, like this is statute of control. I'm like, know that? Nobody mentioned, I'm sure as I got into the research, I would have found this out, but just at the initial meeting when they said, hey, I've got this issue with the architect, it didn't pop, it popped to his mind right away.
Yeah.
And he knew the code section and
Yeah,
everything.
he does that. He does that.
And
And it's a valuable lesson because you don't, I mean, the really, really good attorneys. and you-
Hi, this is Harold Hotline number 760-413.
You figure out
4602, and the temporary bridge
it's a
just
medical
came
knockout
off
practice
in
case.
my upper right, so I'd really like to get that replaced or reseated or whatever.
Otherwise.
Tomorrow morning, if at all possible, this is Tuesday evening, and my number is 760-413-4602. Thank you.
So that is also another good lesson. Do it in the beginning, do it up front, do your investigation up front, and decide.
Yeah.
This is a good case.
so I've enjoyed it just because it seems like every day I'm learning something. And,
We'll never stop.
I
That's
I
for
have-
sure.
I got tasked last minute. I need this complaint, I need it now.
Got the real file.
Okay. So I'm working into the night, come in early the next morning, I get it done. And it still takes me a while, because I'm still looking at the form books on what I allege and for all the different causes of action and give it to the partner. And he's like, yeah, you gotta put some calls there. You can't.
Last week, it wasn't their fault, their client died. I go, I'm sorry, the client died of conservatorship or stuff like that. And I said it on the record, I wish I'd known before I got up at 4 o'clock. to read everything a second time. You can't get mad.
Yeah, get some ice skating.
Yeah.
That's cool. You know what? I just lost this stupid crown.
Do you find it?
Oh, no, it came off. So, I mean, I've got the temporary. But it kind of hurts.
Go home.
So,
Yeah, we're just gonna do some problems now.
okay.
Yeah.
I've not done this every year.
He brings up his gummy bears.
You know, what really frustrates me about this is the second time we will have had to reseat this.
I've had it happen twice.
And it's just,
Who's your dentist?
Hodgkins.
Is he good?
Great.
Cause I got a guy, what they can do is.
Yeah, no, this is just covering where they extracted a tooth, they're gonna put an implant, but the bone needs to heal until they can put the implant. So I'm supposed to go see them in a couple weeks anyway, to see how it's healing and schedule the, put the implant, all that.
It hurts.
But it's,
Yes,
We all hate that.
We got that.
There's a reason.
Hate this.
And there's a reason.
yeah, anyway, thanks.
All right, review next week.
It won't get you out of civil.
No. Yeah.
Library. Yeah, library. It's cheaper than. I should do that. I'm trying to get a break. Maybe I know.
Sometimes those are permanent, you know,
Oh,
I was just like,
I would say it's the last week.
Hmm?
It's your last week. The printout.
I know, that's what it is.
Okay.
I'm gonna do it.
Yeah, I know. I didn't know. It's,
Because I don't know what person is.
oh,
Even person is fine.
it's on data.
Hmm?
On
Yeah,
data.
it's the pay, so my phone was like, $140. It's all paid, all paid. I'm like,
Nice. It just gets slow after a certain amount, right?
yes.
Yeah. Is it T-Mobile?
No,
No?
it's Verizon.
Yeah.
No, that-
T-Mobile.
But for the, it's like,
Okay. Wait, you watch Netflix? You watch Netflix?
I did,
Yeah, it's got to Narco.
but,
Narco Mexico.
oh no.
I just saw that. This is what drugs.
Huh? I watched, I've been to watch hospital.
Ooh, I get back into it. I was on the second episode. I was on the second episode.
Oh my God.
What did Crazy Camera tell you
Because
in
of
the
the
interview?
whole scandal, they did like
Isn't
3
that
months.
technically hearsay?
Oh, oh, Kevin Spacey.
Yeah, yeah.
First.
You smell no longer.
Oh, and that's both
We're going to do it actors.
One of my people, inconsistent statements.
No, I'm
You
just.
can use for consistent statements of only that is witness to challenge and inconsistent first. So,
I don't put
but you can't be like,
Because.
didn't this person tell you this?
He should, he said she said.
Or no, you could say that because then it's not hearsay, but as far as saying,
I mean,
what did he tell
So
you?
let's say the officer testified first.
no,
Let's not create evidence. I talked to this
it
one.
was like, so many years ago.
That's all I can say. I talked to.
You can't say anything that he
I talked to
said.
Karen.
I'm sure.
I talked to Ray. I talked to
Like,
Marlon.
the guy's mom,
What they
why
say.
would you send him over to that party?
Right.
You know, he's
But
got.
let's say Cameron testified. Right? Cameron could be impeached.
I also don't believe.
If you tell the officer this, right?
Hmm?
And
Yeah.
then the officer.
People are trying to hurt, I
can
hate
take
people
the
trying to
stand
hurt
and say,
that and just.
It was just
You
moving.
can't tell the whole
Me
story.
too.
But
Yeah, that's-
those
that's-
specific statements, he can also.
Either corroborate or impeach them with.
I think it goes, I think. Anything.
You can.
Well, you can't, I mean,
If you're confirmed with that, you have to
Oh, yeah, she said it.
Or you have to use them based off of statements or alter them with prior consistent statements. But you
Oh, I
can't be
know.
like, what did
I heard that.
so and so tell you? Because
So it's,
that's
I just, it's a shame that.
Yeah, it was.
I was thinking that last night as I was creating my questions. I was
Yeah,
like,
she should, timing, you know, it happened before.
Well, that's why the officers,
Just talking about
when they interview people, they're only there, you just pick out the parts of that interview that you like.
But it's not the same show.
You're gonna get,
I haven't seen it, but I have no interest.
you're gonna, you get the officer this.
No.
You don't have to really have, no,
Oh,
it doesn't help you all that much.
Correct.
It's like.
Unless they're there to see it happen.
Unless they say, no, I didn't say it. Okay. The officer didn't he tell you?
Mark Star.
Yes, he did.
Oh, no. Yeah.
Yeah.
Yeah. You choose your night, but I don't think she did.
And that's not something.
I don't think they were trying to
I
figure out,
would.
they were just trying to get her out.
Refresh the records. I
Yeah.
can see if you want that. I'm gonna have consistent statements. You're not gonna say, well, then you come out for this. Nope.
Usually leave it at that.
You know, you can have that
I'm sorry.
And then you ask the
I was out of line or whatever. No, you're fired.
Now the opposite.
Yeah, I know what you mean.
You know?
That's a
No
good
pressure.
question.
It's very
So you
much-
think it's like-
Yeah.
Oh, yeah, yes, you did.
Yeah, it's software. If you
Yeah.
want people to do, yeah.
But no, everything he's being told
And then,
is, here's that.
well, they should
All out of
do
court
it.
statement.
Like, well, you know, just cut off. Like me.
That's what You called the officer first.
What?
What's it, what's the scene?
Yeah.
I have to hammer. What did he say?
Thanks, bro.
Objection.
Relationship.
You get-
Because of that, yeah, well,
Then what did
it's
you
like,
say? And I talked to this person. So you can
Next.
get in.
That's what it's at.
That's what
next, I'm like, okay, cool.
But
I'll
stop.
stop. That'll keep me busy for the movies.
Then what would happen is.
Yeah.
And you keep so.
Oh, yeah.
First.
I can't even go on dates.
I don't ask you many. Right?
Be like, hey, I'm not free until the 16th.
Then.
I'll do this.
I mean.
I have a friend I'm seeing, kind of like, I would
Then call the officer.
Right. Law schools, every time law school's in, like,
In something like.
try to get away till the holidays.
I canceled
I don't know
my
why.
My friend in school. His wife coming in town, they've been, I don't know.
You can't get it,
managed
and
contract
then-
down there. But-
That's very busy.
I don't know, I should have see it. I see my trust you. They came in, it was like a week before, did you have a
Oh,
And I said,
Yeah,
I
sure.
canceled last night, I was
All right,
like,
there you go.
Yes.
I can't take a check right now. You know, because you have to get ready, you have to drive home, that's it. I mean, it's, you know, eat dinner, you know, do that. I don't have time. And I don't, you know, I don't know people who are on Wall Street. It's hard for people to understand.
Take a
We
break.
understood, but
You gotta tell them, I can only handle you for an hour and a half. Boom.
it's hard.
Whatever we're talking about, I'm out. You can just bite your tongue. Tell me the rest later.
But all my friends here, they're like, after the 16th, in fact, my friend changed her party to the 16th. She was gonna have it Friday, she's gonna have a luncheon, you know, the Christmas luncheon.
Mhm.
Because I can't, you know, first of all, Carlsbad.
Mhm.
She's gonna have it Saturday night. I'm like, well, I'm gonna be a zombie. Because
On Saturday night,
15th.
Yeah.
I'm gonna be zombies, right?
I got that day off from my graveyard shift job, so I can actually be refreshed.
Well, I hope you got a day on the finals.
No, all finals and midterms, I come in after work. Yeah. Kind of like knocking out,
What do you mean?
for real, yeah, after like. I
You
come
were
in
at
after
night then?
Yeah, I just never, yeah, my first year, I just didn't set boundaries, and I could just do it. You know, I can say, I'm not gonna take time off for baby bar, I'm not gonna request a day off for so dates. Yeah, I was like, now this year, I'm just much smarter about it. Midterms, I was like, I'll just come in after, and I was like, yeah, I learned my lesson.
Oh my God, you
You know, I was going to say during
Oh my God.
the finals of last fall, I was falling asleep in the MPs. So,
Never admit being
I
lying.
thought for sure you didn't.
Are
thought I
they
was-
really
you
that
didn't thought it was
blunt?
wrong.
They're just very blunt.
Oh, sure.
Absolutely.
I think people like, it's gonna hurt their feelings or something.
Sometimes you want to hurt their feelings,
Okay.
you know?
It just comes straight out.
Like I said, it depends, right? If I've got little sweet old lady grandma, no, I'm not gonna be rude to her. I'm gonna be nothing but polite and friendly, right? But I got stupid criminal, you know, with the tattoos all over his face. Yeah, gonna be blunt with.
He has feelings too.
I have a question. Do you think as, when you're picking a jury, would you want or not want a Boston in?
Probably would not want. I probably would not want because you keep in mind, it took me a while to get there, but I am of the opinion that I'm the shepherd and I want a whole bunch of sheep. I will tell you what I want you to do and how I want you to think. I don't want anybody back there telling my sheep here's what I want you to do. Here's what I think, you know. I want one person that I think I bonded with, that's got a strong personality, and we're usually pretty good about it. We can usually tell that person's gonna be the foreperson that's, you know, going in. You know, I don't necessarily want a whole bunch of independent thinkers. You know, and law students tend to think they know, or they want to show that they know the law, and they may not necessarily follow the law as I want them to. Right? The judge just instructs them. I will tell them what it means. And I don't want anybody going back there saying, well, let me tell you what it really means. You know, Mr. Nolan told us this, but that's not really. In my class, we were told by Sue Standing and John Dolan, they told, no, I don't want any of that.
So in other words, if we get called for a jury, make sure we say, we're former law students or former law students.
Yeah, 'cause I
So-
remember I said, when I was before I started law school, that they asked me what I wanted to do. I said, well, I want to go into to law school, and I was part of the 12. And I saw immediately the prosecution was like, she was kind of like taking notes and started like asking me questions. Before they even came out, I'm like, she's gonna kick me out, and I was the first one out.
Right. That's, yeah, I would not want a lawsuit. So, like I said, it's and don't get me wrong. When I say I want sheep, I don't mean dumb people. I don't mean, you know, people that can't think for themselves, but I want people who are going to follow my lead, right? I don't need 12 angry men going back there. We're going to decide this. What do you think? What do you think? No. I want them back there, and I want their arguments to be, well, Mr. Nolan said this. And that's what, you know, that makes sense to me. Mr. Nolan told us this. And use my arguments to rebut whatever the naysayers may say.
So then what a defense attorney want? A law student?
See, they have different goals, right? A defense attorney, and most of them will tell you, they're not going into a trial thinking, I'm going to convince 12 people I'm right. They need one. That's all they want. So they're looking for that one that they think might vote not guilty. And they want that person to be as strong as he can be, right? Because when they say not guilty and 11 other people say guilty, are they going to be able to withstand the pressure and not change their vote? Okay. And that's why I tell the jury in my voir dire, I totally say defense attorneys hate my voir dire because I basically spend all my time telling them all the tricks a defense attorney is going to do and get the jury on board with seeing things my way, or else I kick them. And you can kick them for cause if they won't follow the rules, if they won't follow the law. If they say I can't follow that law, that's grounds to kick them. And I don't lose any peremptories. I can kick them just for that reason. And the judge tells them, and this is I have a whole routine that I set up to get there. But you know, defense attorneys will sometimes voir dire, and they'll tell them, so my client's entitled to 12 individual verdicts, and can you stand up and hold your ground if you think you're right? If you're not guilty and you think you're right, can you stick your ground? And yes. And my experience is most people who vote not guilty generally have a hard time articulating why they're not guilty. Well, I just don't think he is, or whatnot. So the judge says that you have a duty to deliberate. Okay, and so I kind of set it up. I set it up in a very fair way where all the juries say, "Yeah, Mr. Nolan's so fair, and he's just following the rule." And of course, I'm going to do it that way, right? You're supposed to base your opinion on the evidence that's presented. And if your vote is not guilty, you're supposed to have a reasonable doubt. So I set it up, and this is nowhere in the law, but it's in the reasonable doubt instruction. So I asked them, "Hey, Brian, would it seem fair to you that if you believe your vote is not guilty, you have a reasonable doubt, right? So would it be fair to you that you share what it is that your doubt is with your 11 fellow jurors, right? And would you agree with me that if you can't even articulate what your doubt is, it's probably not reasonable. It's more in the possible and imaginary doubt world." And yeah, and the defense attorneys hate it. They don't have to articulate it. They don't have, the rule doesn't say they have to articulate it. But see, I set it up as a matter of fairness, right? Wouldn't it be fair? So they can consider it for themselves whether it's actually a reasonable doubt or not. So you should be able to, and I tell them this in voir dire, you should be able to do two things. You should be able to articulate what your doubt is so that everybody can evaluate it. And you should be able to point to the evidence that supports that doubt. And if you can't do those things, you're not giving me a fair trial. And I like I said, I set it up, but basically the judge will tell them they have a duty to deliberate. And it's not okay for you to say, my vote is not guilty. I have a reasonable doubt, but I'm not going to tell you what that doubt is. See, that's how I've set it up. Right? The defense just said, will you not change your mind? Well, I've now added, will you tell them what it is? What's your doubt? I don't know. I can't articulate it. Right? Well, now I'm not saying you get kicked because you don't articulate it. I'm saying you get kicked because you're not deliberating with your other jurors, and you have a duty to deliberate. It's not okay to go back in the jury room and sit on your hands and sit there like a potted plant and say, this is my vote. I'm not going to tell you why I'm voting that way. I'm not going to tell you what evidence I'm relying on to arrive at this vote. That's my vote. That's not a fair trial. That's not deliberating. And some people say, no, I can't do that. All right, gone. And then the defense gets up, they're all mad. You can't say that. You know, the judge is going to tell you how to deliberate. He's not going to say anything about, articulating what your doubt is. That's just fair, right? If you think you have a doubt, shouldn't you share what it is? So it's like I said, it's a fun trial experience. I used to hate voir dire. I got to the point where I loved voir dire because I could, for the most part, shut down a defense before the case even started. So I knew what their arguments were going to be, and I got to get the jury on my side about how they look at these things. And then I come back to it in my closing argument, in my rebuttal, not in my close, after the defense is done. Now remember, you guys all gave me your word that you could follow the law and you would deliberate, right? You would go back there, and if you think you have a doubt, you would share it with your other 11 jurors, right? You would be able to point to the evidence to support it. Because if it's not found in the evidence, then that's not a verdict based on the evidence, right? And nobody does that. They're not going to go back there and say, here's what my doubt is, and here's the evidence to support it, right? So I've already insulated against any not guilty verdicts. And it's funny, after I started doing that voir dire, I never gotten not guilty. I never lost another trial. And I felt like, man, I wish I had done a better voir dire years ago. But you really can, and I say manipulate, but it's setting up the case on your terms using the rules and the guidelines that are given to you, and not letting the defense set it up on their terms. And most people simply, they're just lazy. They don't do the work, and they think they're just going to come in and my client has a right to, be silent, and he's presumed innocent, and you'll honor that, won't you? And I'm just thinking, keep talking, because you're not scoring any points. You're not moving your case along. You're not helping any defense argument you're going to make down the line. And I, without fail, I got up there and I would give my talk, and the jurors would nod and they'd smile and they'd think, yeah, Mr. Nolan's the nicest guy and he just seems fair and he just wants to help us do our job. And without fail, the defense attorney couldn't get up fast enough. Right? They just jump out of their chair. Oh, Mr. Nolan, Mr. Nolan. And they're just very excited and they're animated because they know I've just undercut their case and we haven't even started. And so their whole voir dire becomes them trying to undo what I just did. And all they're doing now is reinforcing it, because now I've gotten a reaction out of them. And then when I stand back up and I'm calm and I'm quiet, I'm just reinforcing. You can trust that maniac? Right? So there's a process to this, right? There's a strategy to going to trial. And unfortunately, a lot of lawyers just don't use it. They just think I'm just going to get up there and I'm going to call my witness, hey, tell me what happened, and stand in front of the jury and vote my way because my witness just told you this is what happened. You might win some cases that way, but you're not really doing an effective job of advocating your position if you don't actually put some time and effort into preparing your case and doing those things. So.
What would you suggest if you were, so you say you're on the defense now, you're a defense attorney, how would you counteract that without, the maniacal, version of it?
Well, I would not do what every defense attorney, and this is no exaggeration. Every defense attorney will stand up there. Who's got the burden of proof here? The people, right? And my client's got a presumption of innocence. You know what that is? He's cloaked with innocence, right? And you're going to honor that cloak, right? And and my client has a right not to testify, right? And you're going to honor that, right? And they talk about all these big constitutional issues that really have nothing specific to do with the case. Okay? If you're not going to talk about the specifics of the case, I'm at least going to talk to you on my turn about how you go about deliberating. Here's the type of things that might happen during a case, and here's why you can't rely on that. Okay? And I would go point by point, and you get to know your opponents. And I know this attorney always does this. So then I would, put together a voir dire about what their tactics may be and why those don't rise to reasonable doubt and why those aren't appropriate arguments to be made. And so if I was voir diring now, I feel confident that I could come and put together a good defense voir dire. I haven't had to yet. Because DAs don't do good voir dire. I've seen voir dire in, what TV shows do you like to watch? Right? Read any good books lately? Okay. Are you Fox News or MSNBC? Right? Hey. I mean, you're not. If you think you're helping yourself, you're not. So there's very few DAs that I think do really good voir dire anyway. But they're arrogant. They think they do because they win. Right? They're supposed to win. The system's set for them to win. Right? They get to pick their cases. Right? They only file those cases that they think they can prove. And then when they win 9 out of 10, they think, oh, I'm really good. You should win 9 out of 10, right? In reality, you should win that. So DAs don't necessarily take criticism well, and that's a bad attribute, especially when you start out young, right? And you win all those DUIs, Right? And you think you're really good, like, okay, well, there's a lot to learn out there. So I share that with you because don't stop learning. And if you work on your cases, really work, it makes a huge difference. Okay, and you can be very successful doing that, as opposed to just kind of successful. So why don't we look at a couple more problems here? Okay, who wants to jump into 7:16?
I'll do some of it. Because if there's not enough for everybody to do, I'll just.
Oh, no, that's just one
Okay.
easy problem.
Sean is prosecuted for allegedly battering Bobby on a Colorado ski slope. The only eyewitness is Sean's sister, Taya. The prosecutor calls Taya as a witness, and on direct examination, the prosecutor questions Taya. Taya, you're the sister of the defendant, Sean, correct? Objection, the question is legal and therefore improper. How should the judge rule? I would think he would overrule it because it's just a factual question.
It's foundational,
Foundational.
right? Is it leading? Yes. Can you lead on direct? You're not supposed to, but if it's basic foundational type questions, yeah. You know, what I would do, and I think I shared this, I don't know if I've shared it with you guys yet, but I remember I shared it with Trish's class. If they objected to something stupid, like, and I knew, you know what's coming in. Like, you know, Sean, your sister, right? Objection. Okay. You know, I would just get on the slow boat, right? And I walk all the way around. So, you've got parents, right? What are your parents' names? You know, okay, this thing, right? And how old, right? I just take it, I'll get all the way around, right? And do you have any siblings? Yes. Yeah, and do these siblings have the same parents? Yes. Older or younger? You know, I have an older brother and a younger brother, right? And just kind of set it up. Is one of your brothers in the courtroom here today? Yes. Could you please point them out and describe what they're wearing? And they find the defendant. Oh, so the defendant is your brother. Yes. And all I've done is demonstrated to the jury what a ridiculous objection that is. And they won't be mad at me for taking my time. They will be mad at the other side for why did you object? If it's coming in, and sometimes if I'm in a sarcastic mood, I would ask, Your Honor, is defense satisfied with the foundation? Right? And, you know, and I've done this a couple times, and after about 5 questions in, defense said, oh, we'll stipulate. No, I'm not stipulating now. You started this because they know what's happening, right? They tried to score a cheat point, and I don't let them score cheat points. Okay? Do I have to? No. But what I've done now is I've also put them on their heels, right? They're going to think twice about objecting again because, oh crap, if I object, what's he gonna do? Is this gonna look bad on me? And maybe they won't object when they should. I lead a lot on direct with my foundational stuff. And I would just wait for them to object because when they do, then I'm gonna overly lay a foundation and I'm gonna make sure the jury knows that it was them that caused the delay, especially if things were going quickly, right? And then I'll start going quickly again, right? And I'll leave like, yeah, see, Mr. Nolan's not wasting our time. Defense is wasting our time. So.
Interesting. Okay, so the prosecutor says, Taya, are you currently facing a criminal charge of attempted murder? Objection, this question is improper impeachment on several grounds. What are the grounds for this objection? Well, it's not prior criminal than the conviction, but it is a conviction issue. Because they're currently facing it.
It has not been convicted yet. So
But
can-
attempted murder is obviously a felony.
Right, but can you impeach somebody for something they're charged with that they haven't been convicted of yet? No,
So
you can't. What if, and I don't remember this question, but what if, the attempted murder was, of, Bobby? Right? Sean's being prosecuted for battery Bobby, and Ty is being charged with attempted murder of Bobby for trying to get rid of the witness against her brother. Right now, maybe it goes to, bias and interest and all of those things. So,
Okay. So the judge should, overrule it. The next question is, have any deals been made in return for your testimony? And objection, what are the grounds for this objection? Was it bias?
well, it's not so much bias. It's right. Assuming the prosecutor knows that there's a deal. If you don't know if there's a deal in place, you've got no good faith reason to ask the question. Assuming you know that there's a deal in place, it goes to show her bias or interest. Right? She's getting something out of this testimony. The jury's entitled to know what it is. Can defense make deals with people? Sure. Sure. Right? Not the type of deal the prosecutor would make, like, hey, you plead guilty and I'll give you a reduced sentence. But hey, you come to court and you testify a certain way and got a nice shiny new car waiting for you as soon as you're done.
Really?
It's not. You're not gonna come to court and
No, I
testify
know,
to
but I'm
that.
saying that,
No, people buy witnesses all the time. Yes. Yes. Now, is Ty gonna admit to that? No. Oh, let's say the prosecutor knows. Right? You got a nice shiny car, don't you? Isn't that your nice shiny Cadillac out there in the parking lot? Yeah. Who bought that? Sean? Has your brother bought you any other cars? Yeah, no. Right, so I mean, you can just use that to demonstrate that there's a bias on her part and she's got an interest in all of this. And aside from just being the sister, right? You don't want to see your brother get in trouble, do you? No. You don't want to see this on his record. You don't want to see him go to jail. You don't want to see him have to pay any fines. You don't even want to see him on probation. Right? No. And they'll usually say no to all that. So and sometimes they'll admit after you've walked them down that road. So you can admit you've got an interest in the outcome of this case. Yeah, I do. Okay, thank you. And you just admitted it. What does that mean? Nothing. It just means that in argument you'll be able to say she's got an interest, right? She's picked a side. You get to consider that and determine whether testimony is truthful or not. So, how about 717?
The defendant, Alexander, is charged with the unlawful possession of a firearm by a felon. At trial, the defendant's friend, Preston, testifies for the defense. Preston states that the gun in question found on the ground near Alexander was really Preston's. On cross-examination, the prosecutor asked Preston whether he and Alexander are both members of the same gang, Red and Blue Violins. Is this evidence permissible impeachment? Well, it doesn't go to truthfulness or untruthfulness, and it's nothing about a conviction of a crime, so I'm really not sure.
Or remember, when all else fails, fall back on what?
403.
403?
So this is gonna. Would you fall back on the actual 403 or one of the variations of it?
This is just a witness,
This is just a.
right? Witness in a, so it's presumptively admissible, right?
Yeah, unless the probative value is substantially outweighed by the prejudicial effect. And here the evidence of Preston and Alexander being members of a gang is gonna be highly prejudicial, and the probative value would also be substantial because I think you can infer that a gang member is more likely to have or be in possession of a firearm.
And more specifically, what are we talking about here? We're talking about impeachment. We're talking about bias, right? We're trying to show that, right, Alexander and Preston, specifically that Preston, his testimony is biased, right? That's very probative because gang members would lie to protect their fellow gang members, right? Not just that gang members would have guns, right? But that they lie for each other. And is it prejudicial? Of course. And so they hear that the defendant's a gang member, you know, they're gonna, and you just do your analysis, right? How probative do you think it is? Right? If you're the prosecution, it's highly probative, right? To go to show his bias, right? You guys are idiots. And almost every gang case I had, whenever a fellow gang member testified, almost, it had to be like 95%. They almost always walked in and they would see their defendant right there. They give him a look, right? Or they pat him on the back. And they would let their homie know, I'm here for you. And of course, the jury is seeing all of this, right? And of course, I would just exploit it, but it's like they can't help themselves, right? It's not enough that they're just coming to do it. Right? They want to make sure, hey, he sees you. You don't have to tell him that, hey, what's up? But they just did. If I was a defense attorney, I would tell them, okay, when you walk to stand, you don't know him, right? Just don't look at him, don't smile at him, don't do anything. But it's like they couldn't help themselves. So I would argue it's highly probative because of course they're going to lie for each
So
other.
I have a question. So it's saying, is this evidence permissible? Like, is this evidence? Is the evidence the question that he's asking him, or the fact that Preston and Alexander are both members of the same gang? So, the prosecutor is asking him this question on cross, and the defendant would then object, or the defense
Right.
counsel would object.
So the evidence is the evidence that they are both members of the same gang. That's the evidence. Is that permissible impeachment?
But only after he answers it, though. The question wouldn't be.
No,
That's
the
what
question
I'm
is
thinking about.
impeachment, right? You're seeking to impeach Preston by asking this question.
Okay. I'm having trouble wrapping my head around it. I don't know why.
Okay. Yeah, don't get too confused. Is this evidence permissible impeachment? It means, are you allowed to ask this type of question? Right?
Right.
You got to have a good faith belief, assuming you have evidence that they are in the same gang, right? Can you ask them this question? Is it permissible? If you say yes, what is it going to show? Is it going to show, Alexander's truthfulness, right? Is it going to show, or untruthfulness? Is it going to show a felony conviction? Right? Is it what is it going to show? A lack of memory? Right? All those things that we talked about as proper impeachment. What is this going to show? It's going to show a connection between the two, a unity between the two, a bias on behalf of his testimony. You're coming here to testify for your homeboy, So that means your testimony, I'm trying to infer your testimony is going to be biased. Don't believe it, jury. They're in the same game. Okay? And the counter to that is, well, as soon as you hear, that they're gang members, you might as well convict my client because they're going to hear he's a gang. And they're at that point, they won't even care whose gun it really is. They're just going to say, he's a gang member, there's a gun, guilty. Right? So that's the 403 argument. How probative is it? How prejudicial is it? And that's going to be the analysis. Is it a proper question? Yes, assuming it meets 403 standards, right? And then you would have to go through that analysis.
So I don't understand though how it's permissible to get in and be allowed to be asked if there's a bias there. That's what I'm not understanding. So if it's permissible.
The bias is Preston's bias. The prosecutor is inferring that Preston is a biased witness
So he's not.
because he's in the same gang as Alexander. That's the bias. So your analysis as to is this permissible is this basically a 403 analysis. Is it probative? Give it a probative weight, and then is it prejudicial? Does it substantial outweigh? No. Then it's permissible. Yes, then it wouldn't be permissible. Okay, and that's going to depend on the judge you're in front of. Right? There's no rule that deals with biased testimony. So the only rule that comes into play with bias and interest is 403. And there's no special 403s for bias and interest testimony. Okay? Do you all see that?
Yeah.
The only thing that the prosecutor is required to, before they can ask that question, is they've got to have a good faith belief that they're in the same gang. If you're just making that up, if you don't know that they're in the same gang, it's impermissible. You're not allowed to do that. You're not allowed to just throw stuff at them and see what sticks. Okay? So, let's look at 718. Same topic.
So, Shawana is prosecuted for the distribution of cocaine. Father O'Malley testifies for the prosecution as an eyewitness to the crime. On cross-examination, he is asked by defense counsel, Father, isn't it true that Shawana was at one time a member of the church where you are the priest, but she quit the church after having an argument with you? Is this question permissible? I would say yes, because it's not actually asking about his actual religion, but what he's trying to do is see if he's like upset at her for leaving the church. Is there some type of, is there interest in
Because of the argument.
Because of the argument.
Right.
Yeah.
Right. You're only here testifying because you don't like Shawana. Right? You guys got in a fight. She quit your church, and that's why you're here saying she did all this. Not for any other reason. Is it permissible? Yes. Assuming 403 allows. Right? You would still come under this with a 403. Is it probative that they got into a fight? Always. Anytime you've got a witness on the stand and they got into a fight or an argument with one of the other parties, that's always relevant. Okay, is it prejudicial? You can make the argument it is, but what's the prejudice? Right? Let's say I know that this is coming in. I know I've got a father testifying, and I know I've got a defendant who quit the church.
Well, also that she got in an argument with the father.
She had an argument with that, right? But maybe on a case like this, maybe I want to fill the jury box with a bunch of people who go to church, right? Because I know I'm gonna bring witnesses forward that are sympathetic to that type of, jury. And so you wanna put some thought into your jury selection, right? Maybe I don't want church-going folks on every case, but on this one, maybe I do. Right, because I know who's coming, and I know I'm gonna ask this question, and I know as soon as the jury finds out that, she quit the church, they're not gonna like her, right? So, is that grounds under 403? Right, you've picked a jury, right? And now you're like, oh crap, well, Your Honor, this is prejudicial because all 12 of the jurors said they went to church, and now they're gonna hear that my client quit the church. No. Right, you can't have a 403 based on characteristics of your jury. Okay, you can't. So, but if it meets the criteria of 403, then you're fine. Okay, nothing wrong with that. You're trying to show that that the father is biased. Right? He's only saying this stuff because he's mad at her because of that argument. Okay. Let's do a couple of the felony conviction ones. I want to make sure you guys have an understanding of how that works. Okay. So let's look at 719. Sylvia is prosecuted for forging signatures on applications for food stamps. The prosecution and its case in chief offers a witness, Wally, who will testify that Sylvia has been convicted of forgery on 3 prior occasions, and 2 was charged with embezzlement on a 4th prior occasion. Are these convictions and the criminal charge admissible, and why? Okay, so Wally is brought in, and he's going to testify that Sylvia has been prosecuted for forgery on 3 prior occasions. Can Wally do that? Can the prosecution do that?
Isn't it just what she's been convicted of? You can't just, like the other one where she was charged.
So let's focus on the convictions first.
Okay.
Yeah. Can you do that?
You can't be specific about what it is.
Well, you say you can't be specific. What do you think?
I said yes.
You think yes? What are we studying tonight? Big picture. Cross-examination and impeachment. Right? Can Wally come in and testify that Sylvia has been convicted of forgery? Prosecution is offering this in their case in chief. And what if Sylvia never testifies? Right, this is character evidence, this is bad act evidence. Unless this goes to motive or knowledge or something else, and even then, you're only going to be able to use the specific acts, not the conviction. Right, Sylvia is not testifying. Sylvia is not being impeached, right? This is Wally being called just to throw dirt on Sylvia, right? Can he do it? No. Can he do it with the charge? No. Right? So now if you look at the second part, if it had been Wally and not Sylvia who was convicted of forgery and charged with embezzlement, would the conviction and charge be admissible? Now, Wally's testifying. Can you impeach Wally with felony convictions? Yes. Now, this is a very generic question. We know that there's a whole bunch of rules, right? Is it within 10 years? right? Is it all that? But assuming if it's just asking you like this, right? Can he be? Yeah, he could be. Could be impeached with the charge. No. Right? But he could be impeached with the convictions. All right. Does the type of conviction come in? That's going to be up to the judge. Sometimes they'll let it in, sometimes they won't. It's up to them. Okay. The key here was impeachment only goes towards who your witness is. You can't impeach somebody else through a different witness. Okay. Mal brought suit against Dr. Sloan for failing to diagnose Mal's prostate cancer. At trial, the plaintiff's expert, Dr. Enos, testified. On cross-examination, the defendant wished to question the doctor about his misdemeanor conviction for willfully failing to file a federal income tax return. Is this impeachment permissible? Okay, it's referring you to a case, but let's take the case out of the equation. Okay? How do you get in a misdemeanor conviction for impeachment? Right there, there were two criteria.
Establishing the elements of the crime, and there was a dishonest act or false statement.
Mm-hmm. Right? So, in order to use this, can the court establish through the elements of this crime that it was a dishonest or false statement? Well, what does this tell you? Failing to file. It doesn't say filing a fraudulent tax return. This just says he didn't file. Is that dishonest or false statement? Probably not. Right? My guess is the elements for failing to file are pretty simple. Were you supposed to file? Yeah. Did you do it? No. Seems like you probably cannot impeach him with this misdemeanor conviction. Okay. May Dr. Enos be asked about a pending suspension of his medical license by the state of Iowa if he is testifying in an Arkansas federal court?
It's pending, so it would be. Because there's no final decision on it, so it's just pending.
Mm-hmm.
So we don't know if it's really, I would say no.
Okay. He's, hopefully you guys agree the state doesn't matter.
Mm-hmm.
Yeah, state doesn't matter. Okay. He's testifying as an expert, a medical expert, talking about, how Dr. Sloan didn't do a good job. Is it proper impeachment to say, hey, maybe you're not such a great doctor after all? Probative? Yeah, I think we would say very. I would want to know that. What's the nature of his pending suspension? He didn't pay his licensing fees, right?
Okay.
Yeah. So I think you would want to know more though, if his pending suspension had to do with, I don't know, his failure to diagnose prostate cancer. Right, that's very relevant. And now you're coming as an expert to say this guy's a bad doctor. You're not going to do this in front of the jury, but you are going to want to do this in front of the judge. If they've got a pending suspension, right? Can you use that in front of the jury? Probably not, because it's pending. Okay,
That's kind of like you've been charged, but nothing's happened on it yet. If, however, in a 104 hearing, and you're trying to determine is this guy qualified as an expert, the judge can consider anything and the rules of evidence don't apply. So you could bring in, or, he's got a pending suspension. And depending on what that pending suspension is based on, the judge might find him not qualified as an expert. So you do still have ways to bring that in, but that's probably not an appropriate grounds for impeachment. Okay. And let's do one more with regards to untruthful acts on 722. Janet is prosecuted for committing perjury during her testimony before the grand jury. At trial, she testifies on her own behalf and is asked the following questions on cross-examination. You were arrested for lying on your income tax statement last year, weren't you? Objection. Improper impeachment. How should the judge rule? Right, you're not impeaching her with a prior conviction or really even a prior arrest, right? That's not appropriate. Well, conviction would be, but she's not convicted. Can you ask her whether or not she lied on her income tax statement? Yeah. Yes. Okay. But what happens if she denies it? Nope, I wasn't.
You have proof?
Well, let's say you do have proof. Do you get to offer that proof in? No, not unless the court determines that it's an important issue to the case. So you can have all the proof you want, but when you ask them a prior question about prior dishonesty, you're stuck with their answer. Okay, that's a federal rule. In California, I absolutely would bring in the proof to show that they lied. Okay, federal rule, you're stuck with their answer. Did you lie? Nope. Oh, crap. I can prove that you did. I can't do anything. Okay. You deceived your boss 3 weeks ago, didn't you? When you claimed you missed an important meeting because your train was late. Can you impeach with that? Kind of the same thing, right? It seems to be less significant, right? You deceived your boss and you claimed you were late, your train was late. Is that a big lie, little lie? Can you use it? Either way, you're stuck with her answer, right? Nope, I didn't deceive, or maybe she says yes. But I think it's going to be a stretch trying to get extrinsic evidence of that end. Okay, so the key with when you're hitting people with prior acts of dishonesty, just know you're limited to their answer. And it doesn't matter if you've got the goods on them or not. If you can prove that they're lying, doesn't matter. You hit them with the question and they say, yep, I did, or no, I didn't. But you've got to live with that. Okay? So then you've got to ask, do I ask this question or not? Right? Because what's the jury going to expect? Didn't you lie on your tax return? Nope. And the jury's gonna say, and then you just kind of left that alone, right? You didn't, right? And then you don't even argue it. Hey, but you asked that with such force. I thought you had something there. So it's a risk, right? If you know you're not going to be able to impeach them, do you even ask the question? Right.
Question about that. So if you're stuck with your answer, of course she's gonna say no. what is to prevent the prosecutor from actually making a complete, like, foundationless accusation, saying, wasn't it true? Because there's always, I would think from the jury's aspect, there's always some kernel of truth in what the prosecutor is asking.
Well, that's when you gotta have a good faith belief to ask it,
You do.
right? So let's go down the road a bit, okay? I've got the goods on you. I know you lied on your tax refund or whatever, right? And I can prove it. Didn't you lie on this? Nope. Okay, I can't prove it in this case, but what do I got you on now?
Perjury.
You're under oath, right? You're under oath and you just swore that it wasn't true. And I got the goods to prove that it is true. I can now prosecute you on for perjury. Well, is perjury a big crime? What if it's a murder case? Who cares, right? Perjury versus murder. I got away with murder, but you got me on perjury. But you have something, right? You still have something there. But you can't just make up questions. You can't. Okay? That's right, because that's something I walked here on. You know, that's something I walked here on. You know, defense asking questions. You know, and now that's not evidence. Because when you agree with me, if that's all it took to create a reasonable doubt was for some defense attorney to ask a question that suggested something else and then not back it up with evidence, then you couldn't convict anybody, right? You can always come up with a question to ask. That's why the judge says questions aren't evidence, right?
Can you remind them that they're under oath before they answer the question?
You can, you know, but if they say no, it's still gonna look bad for you. You know you're under oath. Yes, I do. And I still didn't do it. Your Honor, they're lying. Take it up with your legislature, right? They're the ones that made the rules. But questions on impeachment? I'm telling you guys, this really is a fun area of the law. And if you guys can, if you put the time and effort in, this can be one of your more favorite parts of the trial. Sometimes it's just benign, and sometimes you just have some person just, they're not lying, they just remembering things differently, and you're just pointing that out. But that's that. Next week is review. Okay, finals are right around the corner. So I will send you the infamous Star Wars final exam. My first year teaching evidence, I actually gave this exam to this class. And they threw an absolute fit. There were some complete nerds out there. They're like, well, we're in outer space, and what rules apply? You're talking about a robot. Did that robot even know? You guys put way too much stuff. Use the rules, right? They complained it wasn't fair, and it was because of their complaints that I stopped doing that. So
It's Star Wars, not Star Trek, right?
no,
Okay.
no, Star Wars. Okay, so I will send it to you guys, along with the outline. Do it, right? I think if you try it, you'll see how things play out, and it may make it easier for you when we discuss it to see, do you get it or do you not? I'm telling you, if you just come in and you haven't looked at it and you just hear us talk about it, you'll think it's easy. Okay, it's not easy. Okay, so but we'll send it to you guys, and I wish I still was writing Star Wars exams. It was a lot more fun when I was writing fun exams, but I don't do that anymore. Now Bob ran into, or not Bob, because that's a B, Paul ran into Dave, and Vicky,
Oh, that's.
right, and Walt, because their first names have to match what they are in the case. So.
I can totally see Chancellor Palpatine testifying at trial.
Now I am, just so you know, I'm an original trilogy guy. So that's my where I live. All right, guys. Next Wednesday, I'll send you that stuff. We will hit our review, and then you have finals. This semester just flew by. It really did. So we don't have a whole bunch that we covered. Character, opinion, impeachment. And it all comes down to 403. So. The lights are on.
Oh, really? Oh, gosh. Hurry up. It's like hard stuff.
I know, I'm having trouble wrapping my head around it. I really am.
Never get the questions, right? Understand the question,
Yeah, they're difficult. They're really difficult. But whatever, finals are gonna come, they're gonna pass, and
I know.
it's gonna be over, So I just need a break, I'm so burnt out.
Yeah.
So burnt out. It's always right around this time, right before midterms too. I'm just like, okay, I've had it. I just.
I know. Yeah, I was saying to myself, like, okay, September's good, October sucks. November, end of November sucks. We're past.
No, I just was checking to see if anybody was in here. I thought I'd turn the lights off while you were in here.
And then, the first part of December really sucks. Yeah, no, like, most of November's okay, but
December just sucks.
Yeah.
That real property was difficult too. That's gonna suck tomorrow.
Is it, I'm doing it tonight.
Uh,
Is it more easements?
Yeah, more easements and servitude and what's the other one? Covenants. So I mean, the cases are just difficult to understand by just reading the cases in the book. Quimby helped a lot. I was like, I don't even know what's going on here. The fact patterns are difficult.
Oh, I always read the case brief. If I didn't, I wouldn't understand, especially future interests and stuff like that. Yeah. Yeah, I think it's just good to, I just think it's smart to read it because it's like, why am I putting all this energy into trying to understand it when I can get the outline through a case brief? You know what I'm saying? Like,
Right.
so I know what I'm going into it, what I'm looking at, right?
Yeah. I'm gonna take a day off next week to study.
I am,
I think it's for sure. I think I need to. There's a lot to memorize.
final,